next case is Long versus the State of Florida. Mr. Thomas?
Thank you, Your Honor. Good morning, and may it please the Court. I'm Gray Thomas on behalf of the appellant, Brian Long. I'd like to reserve 5 minutes for rebuttal. We've raised 4 issues on this appeal. One involves an issue of an error in the judgment to which the state has agreed a correction needs to be made on remand, so I won't spend any time on that. But in one of the issues, though, we have a circumstance where evidence extrinsic to the trial, or circumstances extrinsic to the evidence presented at trial, threatened to affect the verdict, and I would contend did affect the verdict. 12 or 13 people who are advocates for a noble cause, bikers against child abuse, wearing themselves so labeled as such, mingled with the jury in the hallway prior to the beginning of trial, but after the jury had been selected. After being upbraided by the trial court, who described their conduct as constituting reckless advocacy, they removed their patches, but even though they were already known to at least 3 of the sitting jurors. Their views were already known to at least 3 of the sitting jurors. And what do? They sit in the pews in the courtroom closest to the jury. This is a case in which they lend their view of potentially intimidating presence, as well as their view that acts of child abuse had actually occurred, which is a prejudicial message to send to a jury in a case in which a defendant is charged with child molestation and sexual battery on a child.
Counsel, you rely on a series of cases, Schutz and Woods and Norris in particular, that involved persons with an interest in the trial sitting close to the jury, but in all of those cases, they were either wearing a uniform or badges with statements supporting their position. And here, although the bikers initially had a badge or a vest, during the trial, they removed that, did they not?
Yes, after being specifically upbraided and instructed to do so by the trial court. The damage, however, had already been done to at least 3 of the jurors. Indeed, 4 of the jurors were questioned to determine whether they should be removed for cause. 2 of them simply said they wouldn't be affected. 1 gave an equivocal answer, and she was removed.
But doesn't the questioning kind of cut against your argument? In Schutz, there was no questioning. We have no idea how intimidated or unintimidated the jurors might have been by the presence of those policemen in that case. But here, the judge did at least take the time to inquire about it.
Well, you have 2 issues. One is the threat of an inherent prejudice, which is the case where you don't have that kind of examination, which is what you have in Woods and Norris and Schutz. But the other is actual prejudice. And actual prejudice, I would submit, was demonstrated by Juror Adams, who, even though he said he could be fair, he then said, I would be very disappointed if we were to run across them in the parking lot on the way home. And under the standards for evaluating whether to remove a juror for cause, which were articulated again in the strongest terms last September by the Supreme Court of Florida in the Matarans case, where there is any reasonable doubt of a juror's ability to be unbiased, that doubt must be resolved in favor of removing the juror. That did not happen here.
Couldn't it also be argued that there is a distinction between spectators who are, for instance, state-sponsored police uniformed officers versus private spectators, such as the ones here, who appeared in the courtroom without any identifying insignia?
Well, sort of yes and no. That yes, I think a law enforcement presence in a case where law enforcement is the victim, such as in Schutz and in Woods versus Duggar, that's pretty darn powerful. I think there's no way to get away from the inherent prejudice there, where they're all showing up in uniform and swamping the courtroom. But then you also have the case, the habeas corpus case of Norris versus Risley, where the allegation in the habeas petition was that the courtroom was populated by people wearing signs that said "Women Against Rape." Well, that petition was summarily denied, and the result of that case was, well, wait a minute. If this is true, there's a very real possibility that the trial was unfairly prejudicial in violation of this defendant's due process rights. And that was a case of private citizens.
But here we have private citizens who are not wearing any identifying insignia in the courtroom. And I, refer to the United States Supreme Court of State v. Ritchie, where, certainly don't we need to assume that the jury has some fortitude to withstand some type of public scrutiny? That in the case of a trial such as this involving sexual battery or lewd and lascivious molestation of a minor, that there might indeed be members of the community who want to view the trial and who may be hostile toward the defendant. Isn't that the role of the jury to withstand that type of scrutiny generally?
Well, but the role of the trial judge under the due process clause is to protect the jury from influences external to the evidence and the law presented at trial. And where that crosses a line, that trial judge has an obligation to step in.
What could the trial judge have done differently in this case, in your view?
Well, the trial judge should have, granted a mistrial, which was requested by the defense at trial, and B, most certainly should have removed Juror Adams.
Let me ask you a question. When in the course of the trial did the trial judge direct the audience members to remove their vests and badges? Was that before the jury was sworn or after the jury was sworn?
The jury, I believe, had been sworn, but what had happened, I guess the jury may not have been sworn, since there was a removal of a seated juror, but I honestly don't recall whether the jury had been sworn. However, what had happened was that when the jury was selected at the beginning of the week to come back later on in the week for the actual substantive trial of the case. When defense counsel arrived at the courthouse and started walking down the hallway to go to the courtroom, defense counsel saw in the hallway this group of 12 or 13 people that defense counsel, without any objection or caveat from the state, described as 12 or 13 burly bikers in the hallway, where he was able to also identify sitting next to 4 of the jurors who had been selected for the trial. And so counsel proceeded to bring that appropriately to the attention of the trial judge.
So these jurors had been selected previously, but interacted with the bikers on the day of the trial, or at least were in the same room with them on the day of the trial.
Yes, in the courthouse hallway. Then the record reflects that the judge, subsequent to this being brought to his attention, had this group of bikers brought into the courtroom outside the presence of the jury, during which period he essentially scolded them and directed that they remove the attire that conveyed the message. My point is, the message had already been conveyed to 3 people who still remained on that jury, if not more. We don't know if there were any more because only 4 were questioned. And so their message had already been conveyed regardless of whether their badges were taken off before the jury was in court.
When did the defense move for a mistrial in connection with these facts?
At the outset, I believe it was. The record reflects that it was may have been even before the jury questioning process began, but it certainly was right afterwards.
Yeah, well, of course, if it occurred before the jury was sworn, you wouldn't even need a mistrial. The judge could just start over with a new jury panel.
And they would have to come back in a different week.
Well, they would have to come a different week, but there would be no impediment to actually starting over again from scratch with,
I think that's a point well taken, that nobody would have been prejudiced. And the one person prejudiced by this circumstance is the defendant.
Well, Counsel, what would be the difference if the bikers had been protesting outside the courthouse prior to the trial, and then removed their vest, walked into the courthouse, again, very hostile toward the defendant? At that point, would the trial judge be required to close the courtroom? What is the remedy there? Because as I understand your argument, it's inherently prejudicial for these, quote, burly men, unquote, to be seated in the courtroom close to the jury.
Well, I think that's a point where the court has to be capable of making these inquiries and drawing a line to determine where the prejudice occurred. What happened to the jurors as they were coming into the courtroom from outside? Maybe nothing. The jury shuttle runs a different route to the courthouse. The record's not going to reflect that, but the judge has the duty to do everything he can to draw the line to make sure that a fair trial is received. One other point I do want to...
Counsel, you're into your rebuttal time.
I see that, and I just want to make very briefly the point about the second issue, even though I think that the third Williams Rule issue is significant too. You've got a search warrant that was executed on the basis of allegations 12 to 18 months old. I would submit that that is no doubt stale. It is vastly in excess of the general rule of thumb of 30 days. Was issued on the basis of an opinion of the officer expressed in the warrant that the hand massagers or sex toys sought to be seized would still have a nexus to the place to be searched 12 to 18 months later, but no basis was stated in the affidavit for the officer to have the ability to render an expert opinion. And the cases relied upon the state are cases in which that expert opinion was justified, and I would reserve my balance.
Virginia Harris on behalf of the state of Florida. I'd first like to point out a few things before I forget, that the judge actually disputes that these people were all bikers that were sitting close to the jury, and disputes it in the motion for new trial. And in volume 2, page 346, he actually says, I brought this group in before trial and it seemed like a different group. And he's talking about he brought the bikers in to talk to them, and that the people who were close to the jury looked like a different group to him. And that's in addition to the record references I already made to him saying that a lot of those people look like family members and were not actually members of that group. In addition, in volume 4, I believe it's volume 4, page 355, it's the first of the trial transcript. The bailiff mentions that there were no interaction between the jurors and the group during the breaks of the trial. But basically, the state's position in this case is that the judge did everything that he could under the circumstances. The defense said that there were only 4 jurors in the hallway. That was corroborated by the bailiff. The bailiff also said that he had herded the other jurors into the jury room so that they didn't have any contact with them. And then, of course, I've already explained about no interaction. The judge did the only thing he could do. He called them all out. He questioned them. He asked them questions about their ability to be fair and impartial. Would this bias them? Did they read what was on the vests? And he also asked them not to talk to other jurors about what they had seen. And the one juror he was even a little uncertain about, he removed her from the jury. As far as...
Well, the judge must have thought that the badges on the vest were prejudicial because he asked them to remove the vest with the badges, right?
Well, no, he was aware of the Schutz case.
Yeah.
And I'm sure he was concerned, because apparently that case is also from that courthouse. And so he doesn't want to be reversed. And so he's taking measures to prevent that from happening. And obviously, you know, this court has held...
What kind of a remedy, assuming that this would... Because I don't know whether you're arguing the judge thought it was prejudiced or he was just being cautious, protecting himself from reversal or whatever. But assuming that that was prejudicial, how would the prejudice be cured if the jurors had already seen the patches and already had identified them as bikers against child abuse.
Well,
I
first,
suppose as if there's somebody who's for child abuse. I don't know.
Yeah.
What this makes no sense to me. But if the point is, if they saw it already, how could you cure the error by asking them to take the vest off?
well, he questioned them, and they said they weren't prejudiced by it. Just because you see somebody in the hallway with a patch on for a few minutes doesn't mean that you're going to lose your ability to be fair and impartial.
Yeah, but do you really think a juror is going to sit there and say, I am so impressionable. I am just so impressionable that I would be persuaded to vote to convict this guy because I saw a patch on somebody's vest. Nobody's going to say that. I mean, the problem here really is that we shouldn't permit this in an American courtroom. Isn't that really the problem? I mean,
Well, it wasn't permitted in the courtroom, actually, because none of them wore any of these vests during the trial. In fact, it's disputed that the bikers were even sitting next to them during the trial together, but what would you have him do, ban people from watching trials?
he could have, as Mr. Thomas said, granted a mistrial and started over. He could have asked them not to sit together in a group, not to wear clothing that identified them as a particular advocacy group.
Well, he did
and
ask
started
them.
over with a brand new jury. That would have taken about maybe a couple hours, and the whole problem would have been solved.
Well, he
Or he could
decided
have
to
granted a mistrial.
Right, he could have, but he decided to question them, and one of them actually said he didn't even see what was on the badge. So there's that, and one was excused. So there's really only two, and the only one that in fact, the defense attorney said, "I only have an issue with LaMonica and Adams. I don't have an issue with the other two." LaMonica was removed, so you just have Adams, who said, "I was disappointed," and he also said he was not intimidated at all.
But if it's inherently prejudicial, is there anything that can be done to overcome that, other than a new trial? Or a new
I
jury?
don't think it was. I mean, he
But
questioned.
right,
Yeah.
but assuming it is inherently prejudicial, there's nothing the trial judge can do there other than to select a new jury or have a new trial, correct?
Yeah, I guess if you knew that it was inherently prejudicial, but the state contends that it wasn't. I mean, you question them. In fact, in regards to Adams, he said, "I would be disappointed." That doesn't mean that you're intimidated. In fact, I note that the trial court said something in the motion for new trial that actually suggests he was more concerned the other way. The trial court says that, and this is in volume 2, page 343, that the jurors seemed offended in tone about the group. So he thought he could be fair, but he actually thought the other way, and this is the person that's observing the tone and demeanor of the witnesses. And the court made it very clear that he observed the tone and demeanor. He did, the appellate court did not, and he believed them. And his thinking was, I'm kind of worried that he was annoyed that they were there, which is actually more aligned with disappointed. He's not scared of them. And it's
Are there not some problems, though, that are kind of like structural problems in the course of a trial? If a judge decides not to give somebody a jury trial when he asks for it, let's say on a felony case, we don't say, well, you weren't really prejudiced by it because there were 50 eyewitnesses and your prints were all over everything and you're guilty anyway, so it doesn't matter. There are some things, some rules, and some issues of due process that have to be followed regardless of what we think the effect might be. And isn't this kind of one of those things?
No, Your Honor. Jurors are presumed to follow the jury instructions and the law. And I didn't provide you case law on that, but I can if you would like. And when they say, I can be fair, they are presumed to be telling the truth and that they can follow the law unless you can prove otherwise. And there's been no proof. And I'm a little concerned, to be honest, about the idea that jurors are so weak-minded that just standing in the hallway and they see a patch, only two of them, that they can no longer be fair. And I would go back to what Judge Rowe was mentioning about people having signs and stuff. I mean, how far are we going to take this? If it's a multi-day trial, are we going to follow the jurors around to see if they see a sign? If they see a sign, does that mean they can't be fair anymore? I mean, when jurors are in front of the trial court and the trial court is looking at them and asking them questions, and they're saying, I can be fair, I can set this aside, I won't talk to the other jurors, I don't see any reason why we wouldn't believe them about that. And the judge took a lot of measures. I mean, he he made sure that they didn't have contact with these people. He called the people in. He told them not to wear this stuff. Even in the motion for a new trial, the defense attorney admits that they abided by this. They were not disruptive in the trial. And there's even a question about whether they were even sitting next to the jurors to begin with.
And counsel, how would a trial court handle a situation in this hypothetical? What if the charge were a hate crime and the gallery of spectators was filled with a readily identifiable minority group that had been affected? The victim was a member of that group. What is the trial court to do there? There's no button, there's no insignia, but clearly there's a readily identifiable group in the audience to support the victim.
You mean just by the race of the people?
By the race or gender.
Yeah. Well, I mean, the only thing he can do is question them and see if it would affect their ability to be fair and impartial.
Wouldn't that be inherently prejudicial, though? And if we were to accept the appellant's argument that the presence of a readily identifiable group supporting the victim will inherently prejudice the jury.
And I don't think you should accept that. And then you're also getting into the idea where you're saying that you're going to start banning people from coming to the courtroom. I mean, what are you going to start telling people? Well, I realize that you're all, say, for example, it's a black person. You're all here and you're black. Sorry, we're afraid this might inherently prejudice the jury, so therefore we're not going to allow a group of black people to sit and watch the jury.
But I don't think the case law has gone that far. I think the case law in Norris, for example, they didn't say, well, these are women and this is a rape case and therefore they've got to be here in opposition to the defendant. It was because they were wearing specific message buttons.
Well,
that's what took the case.
In that case, and it doesn't appear from the record that they ever actually asked the jurors, or not the record, the opinion, whether or not they would be affected, even the post-conviction proceeding, which by then, who knows if the jurors would remember by then anyway. But these people were not only wearing buttons, the opinion mentions they were actually selling or either giving drinks or something like that. I mean, that's way above what we have here. In this case, these people were stopped before opening statements from going in there. The jurors did not have interaction with them. They didn't wear this regalia. We don't even know if they were there. I mean, like I said, the trial judge, numerous occasions, disputes that these people were even sitting next to the jury to begin with. He says these looked a lot like family members. There were a lot of women, and I don't think this is the same group that I talked to.
Well, if for example, in the Schutz case, the judge had questioned the jurors, and the jurors all said, I know that there were 50 to 70 policemen sitting there in the audience, and they were all in uniform, and I know that they were tacitly trying to convey the message that this guy did know that the victim was a policeman, and I know that they were there to show their solidarity for the victim, but it didn't affect me. If there was a record in that case, would you advocate that the Schutz case should have been affirmed?
I would definitely make that argument. I'm not sure if the court would have. The court mentioned in there about part of the defendant's theory of the case was that he didn't recognize the police officers, and so this court felt like them wearing the different uniforms was, affecting the theory of the case. So the state would make that argument, but I'm not sure if under those facts it would have changed the court's opinion because of that added fact.
And counsel, couldn't that case also be distinguished under the logic in the Carey case that there may be a distinction between private spectators and state-sponsored spectators, such as police officers?
Yes, and it also mentions that they were talking about the police being there in solidarity and showing their different uniforms. And this case, they distinguish that. Schutz distinguishes that from people going in with clothing to support the victim. These people were going in to support the victim. In fact, if you read the depositions, apparently they even showed up for the depositions because the defense attorney mentions, I see bikers out there during the deposition. So these are people, when you look at their mission statement, which admittedly I saw in the motion for new trial, they're there to support the victim. Victims of sex cases have a lot of trouble, especially children, people under 18, testifying about these kind of things, which is understandable. And they're there to support the victim. They're not there to scare anyone. In fact, I quoted the judge who, in my opinion, was refuting the defense contention that they were intimidating. He's saying they don't have beards, they don't have tattoos, they're not chanting.
They didn't have leather or chains or anything
yeah,
like
and
that.
He said they look like they spent a bunch of money on a Harley Davidson, which I'm from Daytona Beach, and we'd call them yuppie bikers. I mean, these were not scary people. And they're not lawyers, despite the fact that the defense mentioned that they were told not to be there. The state attorney actually said that she told a couple of them. It doesn't mean who were there on a previous day not to come. It doesn't mean they have all the phone numbers or know all the people in the group and could have told them not to do that. They don't know that they're not allowed to come to the courthouse wearing that stuff. When they did, the judge told them not to do it anymore, and they didn't. And what else could the trial judge do? The defense attorney did actually ask at one point to ban them from the courtroom, and you're getting to a point where you're infringing on their rights. And I think the trial court handled this the best way that he could. In regard to the motion to suppress, in that case, I would like to point out that a lot of the things that the officer said, you don't even have to be an expert. I mean, the fact that a dildo or a vibrator is made of synthetic materials to be reused, that's not, I don't think you need any expert opinion on that. And he didn't just say that pedophiles would keep that. He also said that it might be around for a long time for personal use, which is also common sense. In addition to that, he had the victim who said that she saw these items in 2009, and the mother of the victim who said all the way back in 2007 that she saw these items. So what you know is this gentleman has kept this item in his possession for a long amount of time. In any event, even if you thought it wasn't sufficient for probable cause, it definitely wasn't lacking in indicia of, he wasn't not acting in bad faith. The cases mentioned by appellant are essentially cases where the police searched something where they really didn't have any evidence that what they were looking for was in that particular place. And that's not what we have here. There's no evidence that the defendant or that the police officer was acting in bad faith or that the judge was. This warrant was fine in the state's opinion. I can see I'm about to run out of time, but I also want to make clear on the last issue. The state's position is that it is not a minimum mandatory in the sense that the defendant is precluded from getting gain time, but the state does not agree that the defendant is not getting gain time. There is no language within that statute that precludes him from getting gain time. The state's position is that he is getting gain time. We can't give you records from DOC because I'm familiar with your prior case law, but we would submit that the defense has not proven that the defendant is not getting gain time. We ask that you affirm.
Just on that issue, the judgment says shall not be released for 25 years. The defense counsel described these individuals as burly men. They were never described as yuppie bikers, yuppie Harley guys. What the judge said was, I believe the record will support this, that he believes that this group sitting next to the jury may have included some non-testifying family members. The trial court did not make a finding of fact about that. If inherent prejudice has occurred already at a certain point in a trial, then there is no remedy other than a mistrial. And under Woods, as the standard of review has been described, there is no review for harmlessness because a defendant has already been deprived of his right to a fair trial, which is one of the most fundamental rights in our Constitution. In the one thing I'll say about Norris momentarily is just bear in mind, this was a bare habeas petition. There had never been an evidentiary hearing. The facts weren't fleshed out. It may have all been lies for all we know. The court was simply stating that if this is true, then this cannot warrant a summary denial. Therefore, it needs to be fleshed out at an evidentiary hearing. Now, regarding the issue of suppression again, the officer rendered an opinion that individuals who have at some point possessed these items would keep them, would collect them, would hold on to them as trophies of sexual misconduct. The only thing we know about this officer's ability to render such an opinion is he'd been with the Gainesville Police Department for 13 years. He'd been a detective for 3. he had had basic law enforcement training, and he was currently assigned to the Persons Task Force. In all of the other cases, which are all child pornography cases, where there is a large body of law that consumers and collectors of child pornography do collect and hold on to those items for a long time, for sometimes until they're caught years later. And the reasons that are invoked to justify that opinion and where that opinion is supported by a foundation of qualification of the affiant, the reason is because it's illegal, it's hard to come by, and it carries a huge social stigma. Sex toys don't carry any of those three marks. Thank you.